So we'll go ahead and get started with the program. We have two really great speakers lined up for you today. OESC Executive Director Trae is going to speak first, and then employment attorney Courtney Warmington. We're very fortunate. We've had some our last two directors at OESC have been fantastic to work with. They've really made an effort to reach out to the business community and the employer community, so we're super grateful for that. And Courtney always steps away from her billable hour to come and present to us on issues that impact employers. She's very passionate about it and passionate about helping the business community. So without further introduction, I'll go ahead and let you get started, and here's your clicker.
Appreciate it. All right. Hello all. I don't see a lot of familiar faces in here, so nice to meet you. I'm Trae. As Kinsey mentioned, I am the CEO at the OESC, and I have some slides here we'll go through fairly quickly so that there's time for questions, and then if you want to have any discussion, Courtney and I may even be able to tag team some of your questions, but just wanted to start with a handful of things that I assume you would be interested in at this point in time coming out of the pandemic. So we'll talk just kind of high level about Oklahoma labor market stuff, just so you know kind of where we are today, the resources and services that are available to you as employers in case you didn't know that or haven't engaged with OESC before. I have a specific item on here around employer engagement because that's a big focus of the agency today and moving forward. And then just a couple things about what we see the workforce of the future kind of looking like with the efforts that we plan to make with our partners. So get right into it. I won't read the slides to you. I can send them if you want them, but I promise I won't put you to sleep by reading slides. And I can't really see that one, so I'm going to walk around a little bit. Just a then and now, obviously we're coming out of the pandemic. That was an unprecedented time for employers and for unemployed individuals. I didn't put a ton of data in here, but just in case you don't know, OESC experienced a significant spike in volume whenever the pandemic hit. We were seeing on average about 8,000 unemployment claims per month pre-pandemic, and 6 weeks into the pandemic that 8,000 claims had grown to 240,000 claims per month. So our system, which is really, really, really fancy 30 years ago, actually crashed, and some of our processes went back to paperwork, which really is good for efficiency. So you can see here, unemployment rate spiked, our volume caused a little bit of a crash, not in everything, but we've been recovering a lot of those things since then. Now, thankfully, we can report that our unemployment is very low. It's been 3.2, 3.4, it's down to 3.2 as of December, which is our latest closed numbers. That's very strong. My guess is you know how strong that is as an unemployment rate, because when it's this low, it's hard to find really good people, so I'm sure you all have felt that. Right now, we do have the largest workforce that we've ever had in state history. Almost half of all citizens in Oklahoma are in the workforce today. And I can talk, if you want, about kind of why that has grown in addition to inflation and people needing more money. There's a little bit to that. But right now, come December, we have almost just right under 2 job openings for every unemployed person. That's difficult to keep up with. Resources and services, just put a few things in here, as I mentioned, kind of as a refresher, if there are things that you don't know about OESC. We produce and publish publicly on our website a lot of job market data and analysis so that you can see trended information. It's free. It's for employers and job seekers alike to get on and kind of understand what's going on across the state. So we would always encourage you to visit our website to see those things. And then just a couple of services listed here, wage analysis, labor force analysis, and then trend analysis. And these are things where our teams go in to the data that we receive from the national firms that publish this data, and they will look at it in specific ways that would be meaningful to Oklahoma. So we see our state data, we also see national data, and so usually there's some opportunity to get in there and look within industry or within geographic areas, because the state behaves differently across, the different towns behave very differently with regards to employment and unemployment. So it helps to be able to zero in on a region or a zip code if you're wanting to know, specific things. So there's wage information that way. There's actually the labor force information is able to be drilled down that way, and then trends, just helpful to look back to see if we're going to be able to predict anything upcoming. A little bit more here on resources and services. Field office hiring events, we have a lot of these throughout the year. We've got today 27 local offices across the state. They all engage in the things listed here, and they're doing it as often as employers reach out and want to do these things. So sometimes there will be months where we have a whole lot of hiring events. I think in October was a peak month, and one town, Tahlequah in particular, had a hiring event where Brahms, as a corporate structure, decided to bring in as many people as they could for hiring events for that region, and then Brahms stores around, and they actually hired and trained 82 people in Tahlequah at one event. So some of these can make a pretty big splash. It depends on the type of engagement we have with employers, but that is a service available through all of our local offices that we would love to hear from more employers and be, assisting you all in that regard. Just a little bit on the referrals and matching. We're maturing as an organization in this space right now, where we're seeking data outside of what's on a typical application so that we can better understand who they are, what they want, and how sticky they will be if they find themselves in one of your organizations. So we try to do a better job of understanding those individuals so that we create better matches in the workplace. Job fairs, similar to the hiring events, we're participating in job fairs sometimes. That's where multiple employers come in. We also have done those at our offices, so we may not host it. It may not be just a state thing or just an employer, who wanted to have a targeted event for themselves. It's something that's, there's more volume of vendors there. And then veteran hiring events, we do a lot with vets and with military personnel. So there are some things where we can get into the communities particularly focused on those individuals. If you know what dislocated workers are, we kind of say at OESC, veterans are like the biggest group of dislocated workers in America. They I think they are certainly deserving of our assistance, and there's a lot of opportunities to plug them in with their training. And there are actually some services that exist through the Department of Defense where we can place people in jobs on the DoD's dime for about 6-month periods. So there are things like that we're reaching out to partner organizations like that and trying to better understand what opportunities exist, so when people come to us expressing needs, we have different ways to kind of matching to those needs. So I mentioned I was going to talk a little bit about employer engagement specifically. This is our most significant strategic opportunity at the agency today. Historically, our agency has not, I'm going to say it the nicest possible way, we have not done an adequate job, in my opinion, of prioritizing employers as a stakeholder group. You all pay the balance of the trust fund, which is used to pay unemployment claims, and you're the largest group of stakeholders that we engage with. So if we understand more of what you need and more of what you're wanting, we can do a better job on our side to make sure that that information is free-flowing. Sometimes it's matching individuals across organizations or across industries, and sometimes it's just playing a role in that individual interaction that you're wanting, like a hiring affair. But every chance we can get to work closer with employers improves our service delivery, essentially. A couple of things here. This specific slide's on fraud prevention. Chris, will you raise your hand? That guy right there is the director over our fraud area of the agency, and this is something we're particularly proud of here, Verify OK. That is the latest and greatest in the nation, latest and greatest fraud detection tool. We actually brought this online in October, and there have been other states since then learning from us, because this is a really, really, really sharp tool which was developed by our team, and we're very, very happy of where that is. If you remember the pandemic, you knew that there was a lot of talk about fraud, and I won't talk a lot about fraud, but there are some things that it would help you to know as employers. First off, we don't talk about fraud a lot on purpose, because there are individuals out there, we call them evildoers, that are looking for a doorway to be open so that they can exploit a problem, a security problem. It happens. There's no way around it aside from matching to it with a sophisticated measure that they can't beat. It will always be a challenge that we fight, and we're lucky that we have a tool right now like Verify OK that, as you can see, that first bullet point has decreased fraudulent claims attempts by 90%, just under 90%. Previously, the fraud process at the agency was different in that, especially when we had the public emergency, there was a lot of encouragement to take care of people as fast as possible. Not having a sophisticated tool like this, that came at some level of trade-off, and that's a challenge. Today, this real-time facial recognition software has to be beat before a claim can be submitted. If someone can't get verified, they're having to go to an office today or go through a couple of the little workarounds to be able to kind of get past that step. It's basically a hard stop. And it's one of the fanciest and most sophisticated hard stops that exist in this space today, which is great for employers because you won't find yourselves fighting some silly battles that aren't really your battles to fight if we can stop it before it starts. So this is a really big step in that direction. Another point just to mention there, the last bullet point, employers not financially responsible for claims filed fraudulently, in case you didn't know that and have a question about that. Another piece to press on for employer engagement is the employer portal. We're excited, very excited about this. This launched in early February, and this, I want to get a couple of cheers and yells in the room. The top box there are the two most common notices that OESC sends to employers, and they're now electronic. Thank you. We have launched ourselves into the 90s with technology. No, I'm kidding. We still got some work to do, but this is a big one. This is something that we've launched and we'll continue to develop so that we can load more functionality into it and give you more of an opportunity to do business with OESC electronically. It obviously saves time and energy associated with tracking things down in the mail, and I'll talk to you just a little bit about a way of improving that kind of on your end, but ultimately it's really costly to print and mail things too. So this is checking the box on some of our important areas that we would like to kind of recover or advance and mature our organization. So this employer portal is a big thing, big step in that direction. So one thing to mention, pre-filing is a thing. If you separate from an employee, you do not have to wait on your notification to come to you. You can pre-file and say, I have separated from this person. It eliminates the need to respond to the notice because you've already responded. And it also ensures that someone seeking unemployment doesn't go into our system and choose the wrong employer or put in the wrong address. Because a lot of times if you're not getting notices, it's completely based on what someone puts into the system. And we have this even with sister agencies where we say, yeah, we know where you are. We're right next door. But if the person clicks the wrong name or puts the wrong address, it's a system. We don't have control over what they submit because it has to be their information that they submit. So it's a mess. If you're not getting notices, pre-filing will help that you've already basically said it's me. Just so you know, the Easy Tax system is where you're making employer tax contributions today, and through the Easy Tax system is where you would basically opt in to using the employer portal. It would link your account so that way you could be getting things that way. Last employer engagement piece, just a couple of things here on hiring assistance. In case you don't know about work opportunity tax credits, there's a description there about dollars that can come your way for seeking employed individuals from targeted populations. Also with federal bonding, there's some just programs that the Department of Labor has found drives an outcome for individuals who their populations, it's harder to find, there's barriers to entering the job market. So there's things like this. They're always coming online with new things, maybe more often than we'd like, to be honest, because some of them aren't great ideas. But there's things like this that we want to have relationships and put our information out online so that individuals can stay up to date and know what's going on. Just last piece here is workforce of the future. I put some things in here that we're working on collaboratively with other partners in this workforce space so that you would know the things that we're already doing. And then obviously if you think there are things that are not being done that should be on this list, then we hope that you'll engage with us. We're real big on communication and transparency, and we want feedback because the agency, we've made lots and lots of progress over the last few months, but I can tell you we're like 1% of the way there. So we would love to work closer with employers because that helps us take larger steps because we're getting it straight from the source. So a couple of things here. Strategic alignment, we started this immediately, meeting with other agencies that touch workforce, doing joint leadership meetings every month so we know what's going on and we're not duplicating work, or we know where their overlap is and can kind of work productively in that space. We're trying to, in every way possible, get to be outcomes focused instead of activity focused. I don't care if someone's real busy. We want to know what it's driving for our customers. Knowledge sharing within and across industry, that's basically setting up things like employer councils where we can grab information. It could be wage information, it could be working condition information, whatever it is that you'd be willing to share, so that way we can advise other employers on how to do it right and keep themselves out of the space of unemployment, or how to retain staff, because some are figuring it out, others are struggling, sometimes in the same industry, sometimes in the same town. Operational excellence, I won't spend a lot of time on this. You probably hear enough about this at work, but this is something that we're all in on right now. And we've got a lot of things that we're working on in the space of improving ourselves for you all. Pilot programs, this is something that we've already started as well, where we're trying to find innovative service delivery models so that if we have some point in the future that we say this local office isn't really doing great, they don't have a ton of volume, there's better ways to serve people, we're on the front end trying to learn how do we get in front of those people, how do we serve them best. At some point maybe we don't need a bricks and mortar office there, just to be honest. We want to go where people are, set up shop, and we're already started doing this where we've set up shop inside employer spaces and we're there for their customers that day or whatever days a week they want. So we're always interested in partnership opportunities like that because it gives us a chance to look differently than just going to our offices every day, which some people can't get to. Technology enhancement. We're not done with technology enhancement. I have had some questions at the Capitol saying, we thought your system was fixed and done. And can I throw up in your trash can real quick when I hear that? Definitely not done. We have a lot left to do in this space, but we have made some significant strides. The two priorities on our technology roadmap were fraud and employers. That's why these two initiatives came out first, but there's more than two. There's a lot left. So that's part of it. And then collective work with chambers like this. Private and public business partnerships. A lot of times there's companies that will want to sponsor programs within educational institutions. So they're printing the type of staff that they want. If they look like this, I'll hire 30 of them every semester. Well, that's a hard thing to facilitate across industry. So we're trying to understand that information and basically walk it backwards to the people who hold the keys to the other parts of that equation. There's a lot of us that work in the same space to drive what should be the same outcome. And so I think there's some opportunity strategically to say, this is your part and we think this is how it would best be provided, or at least this is the outcome we need of it so that we start on the right foot. That's it. I'm happy to answer questions or give it straight over to Courtney and then take questions at the end, whatever y'all want, but that concludes my programming.
Supplemental funding from that.
Supplemental funding for fraud specifically. Chris, you know the answer to that?
There are several grants in that space for different programs that came out of the pandemic. As far as only being one of three to get those, no, there were many states that acquired those grants. The problem is, $3.4 million sounds like a lot of money to a lot of people, but tech is expensive. That hardly covers much of anything. So there wasn't really a whole lot of many dollars out there for the states to get. But yeah, Oklahoma, we for fraud specific for pandemic programs, we were awarded a couple of grants.
We do have some grants that we were one of a few that we got for excellence in operating some of our programs. So we were one of 3 states in one of those. We were one of 4 states to be recognized for going 3 years without a finding in some of our audit areas, like trade assistance programs that are pass-throughs for our agency where we can line up certificates or trainings for people entering the workforce. There are some of those programs that we operate where we were recognized in just a few, company of a few. And then we're always seeking federal grants. We're kind of, I would say, maybe a little unique in that we're not seeking state funding for our operations. We think the right way to go on a lot of this is to say, if we can cover, this technology project, we go out and find grants for the things that are important to our employers. We can say, this problem exists in the labor market, and we think we've got a solution for it. Certainly there are grants out there that are meant to drive those outcomes. So we've recently set up a grant manager within the agency so that we can say, here's our strategic focus. Here's our roadmap for technology. Can you go find things that match to this so that we're not asking the state for dollars? Because that's the whole reason those programs exist. So yes, and hopefully more to come.
I have a question. What's the best way to report fraud? Because right now I think we're probably doing an old school way. We just write fraudulent on the form and fax it to the fax number on the form. I didn't know about the website or that database. That sounds really cool. What's the best way?
Yeah, well, so I would say the two best ways, whatever works best for you. If you are responding to a protest electronically, maybe you can report it that way when you do that, or you can go to our website and you can report it that way as well. That would be for any citizen, whether you're a business owner or not. Go straight to a dedicated fraud team that will have their eyes on it the same day.
What's the website, or is it? Where do we go electronically? Because right now we're just all paper.
Yeah, it's our OESC.
Oh, okay.
.gov website. Yep.
Just that main website. Okay.
Yes.
Okay. Great. Thank
question?
you.
Yes, ma'am.
Just a follow-up question on that. Once one's been filed, should you hear anything back? I mean, that several we filed and never heard anything.
That depends. Because of the volume, it's hard to have an instant response to everybody. I can tell you if you don't get a response, I can't guarantee that somebody is working on it. That sounds like, a big guarantee there, but I see them every day with that team. Because of some of the tech we were able to stand up, like Trae mentioned, 90% decrease. We're not seeing as much, but there's no one piece of technology is a magic wand that's going to fix everything, right? So if you stand something up like Verify OK and it works, it stops those bot attacks, it does everything you really want it to do, and you surround that with a good team, you can really work magic. So I think that's why, you should start seeing more of a response, even if that volume is very low. If it's just 2 or 3, it's not like 300 or 400 like we saw back during the pandemic. But I can guarantee if you submit that, somebody is working on it same day.
Yeah, that's new. That process online and the team at the agency, those workflows were set up once we launched this new tool. So we're continuing to kind of mature ourselves in that area, but I will definitely echo that the team is really, really strong and they don't have any kind of backlog. So we can talk internally about responsiveness just so that you know what's going on as a customer, but that's all fairly new last couple months. I may go ahead and just pass it to Courtney. That way I'm not shorting her on time, but if you have other questions, I'm happy to answer more.
Thanks.
Yeah.
I had the chance to have lunch on Friday, and I got a chance to visit with Trae, and just really am looking forward to having the OESC under your leadership. I will tell you, you'll hear me say a couple things today about how different it is there now than it was a decade ago, and the things that we're seeing on our side as lawyers are just so good, and I'm so grateful that we've got your leadership there, which I know is going to continue some of the things I'm about to tell you about. I thought for purposes of our time today, I would just focus on some practical advice, specifically as it relates to unemployment hearings that I've learned the hard way. In my early years, I did these all wrong. I did not get it. I had the wrong issues in my mind. I approached them the wrong way. And over the course of the last sort of 23-ish years, I finally figured out there's really 3 things that I'm always thinking about when someone calls me about an unemployment claim. And these 3 things I wanted to share with you today. They're really kind of 3 key decisions that I think an employer has to be thinking about before they're even deciding if they're ever going to respond to a claim. Now, in fairness, the lawyers don't get the run-of-the-mill questions on claims. I mean, lots and lots and lots of you handle unemployment claims, and you never involve a lawyer, and you do it all the time, and you've got your system, and it works well for you. When the lawyer gets a call about an unemployment claim, there's usually something that's just a little unique, or the employer's a little bit concerned about. And so these are the three things I'm always thinking about. And the first one is there actually any real chance you're going to win this? And that's a hard conversation that I have to have with employers sometimes, because they have a, what I'll call sometimes just a misunderstanding about what deems you eligible and not eligible for benefits. And really it boils down to largely what's the definition of misconduct. If you're challenging an unemployment decision or an unemployment application, usually you're dealing with one of two things. It's either you're saying they left voluntarily or they engaged in misconduct. Those are of those two, usually the employers that call me are dealing with the misconduct piece. Okay, and so I start talking with the employer. Well, tell me what they did, and let's see if that actually fits into the definition. So, what is the definition? Actually, I know it's kind of small to read, and we'll email this out to you. Prior to 2014, just to give you a little bit of history, we had no definition of misconduct in the statutes. It was just largely based on case law, and it had been developed over time, and I'll talk about that in a minute. But in 2014, the legislature actually codified what it means to be terminated based on misconduct, and they came up with 8 specific things. Again, I'll just go over these really quickly with you, but the first one you can see is any intentional act or omission which constitutes a material or substantial breach of job duties. You've got unapproved or excessive absenteeism or tardiness, indifference to or breach of or neglect of the duties which should be expected of someone in that role, acts or omissions that place in jeopardy the health, life, or property of self or others, dishonesty, wrongdoing, that's a pretty big catch-all, violation of law, or a violation of a policy or rule enacted to ensure safety and proper job performance. So those are the 8 things that are now in our statute that qualify as misconduct. Now, the legislature added a couple other things that were helpful. It said, look, whose job is it to prove this? Well, when it comes to misconduct, the burden is initially on the employer. So it's our job as employers to establish misconduct. Once you do that, the burden shifts over to the employee, and the employee can then try to show, if possible, that either that's not really what happened, or that happened, but it just doesn't rise to the level of misconduct in the statute. So that's the way it works. And they also added a couple final things. They said, look, you don't have to have given them a prior warning. That's not required, as long as you can show that the employee knew or should have reasonably known that a rule or policy of the employer was violated. Now, in practical terms, it's sometimes hard to do if you haven't given them something in writing showing that, but nevertheless, that's what the statute says. In theory, you don't have to actually have a prior warning. So you read all that and you think, okay, well, that sounds fairly straightforward. I mean, wrongdoing is a lot of things, and you don't actually have to give them a warning. So it's easy, right? Not easy. It's not easy. And so that's why the first thing I'm always going through with an employer is, look, I know you have lots of justifications for your termination, and they all sound very good. And I understand why you did it. But you're not going to probably fit under the definition of misconduct. And we're going through that process and trying to decide, is this even a thing that you should be objecting to? Part of the reason it's so hard still is what I would say is what I'll call just the historical definition that we have of misconduct. The one that dated back before the legislature added in all the reasons. And again, I won't read the whole thing to you, but it's largely based on that used to always be cited in all the opinions, the orders you would get, is the Vester case. If you've done this a long time, you've heard of Vester. It was always cited in your order of decisions that you got from the OESC. It's not cited anymore, you'll notice. Now they cite the statute. But nevertheless, we have this long-standing history of this idea that misconduct really ought to be something pretty bad. I mean, it ought to be pretty intentional, regardless of what the statute says. I think that this is still kind of woven into and embedded in the way our hearing officers think of unemployment claims. I'm not saying it's wrong. I'm just saying that's what I think is true about unemployment claims, is that we had for so many years this idea of misconduct. You know, a lot of people can be bad at their job, but misconduct is a different thing. And here's the one that really always tripped people up. is the second part of the finding in the Vester case, which is mere inefficiency, unsatisfactory conduct, failure in good performance, on and on and on, good faith errors in judgment, discretion. That's not misconduct. And the problem is lots of terminations fall under that umbrella, right? Sometimes people just aren't good at their jobs. It just doesn't work out, yet it's not the kind of intentional behavior that really is intended to fall under that definition of misconduct. So, it's questionable whether that's the right standard anymore after 2014. There really only been 2 cases I can find in Oklahoma that cite to Vester after 2014. One is a Court of Appeals case where they cite it. The other one's at a Court of Appeals case where they act like it never existed. So I don't know what the answer is, but nevertheless, I think it's still woven into our ideas in Oklahoma about when someone should be eligible and when they shouldn't be. So that's the first thing I'm always saying is, are you sure you really want to contest this? Because you're probably not going to be successful. But even if you say, yeah, I think we're going to win, or I don't care, and we just this is our practice, and we make a practice of responding, and this is what we're going to do. The second thing I'm always asking and thinking is, are you about to do more harm than good? Sometimes I can just see that we're sort of headed for a lot of problems in the unemployment hearing. Why is that? Well, it's because testimony that you give at an unemployment hearing is recorded and it's under oath. And what you say can and will be used against you later in litigation, likely, if you get into litigation with an employer. So I know our OSC folks are probably not going to like me hearing me say this, but the truth is, if I have a client that tells me we're kind of headed toward litigation, or if I know they have a lawyer on the other side already, or if I can hear that your reasons for termination haven't been fully articulated well yet, or you're still kind of struggling with articulating it, or you're still digging into what kind of led to the termination, 99% of the time I'm going to tell you, wave off. Wave off. You do not need to attend this unemployment hearing. Now, the OESC will ask you to respond anyway, because, and rightly so. I mean, they're protective of the fund, right? And they should be. Because it's got to be available for those who need it. And to do that, it can't be available for those who don't. And so they don't know what happened really unless an employer responds. And so understandably, they can sometimes get a little cranky with you and want you to respond. They say, where's your response? You need to respond. What do? I send back a letter that just says, here's the dates of employment. Here's the general reason for termination. I'm not saying all the reasons, but here's the general thing. And we're not participating in the hearing. Here you go. Here's the information. Or also even submit the documents sometimes. You can submit the documents. You can submit your letter. You can do all of that. You don't actually have to attend the hearing. I know. Cover your ears, OESC, because you're probably not liking that advice. But it's true. There are things that are worse than having another unemployment claim and maybe your experience rating going up. There are things worse than that. And it's called saying a thing one time and then saying another thing later. And it's a problem. It's a problem. It's called pretext if you're changing your story about termination. And so I get nervous about sometimes, not always, but sometimes I get a little nervous about, do you really need to be attending the hearing, even if you think it's a slam dunk, even if you think you're going to win. Now, some employers say, though, yeah, but wait a minute. If I don't attend this hearing, doesn't it look bad? Doesn't it look like I agreed that I terminated this person for no misconduct? Isn't that going to be admitted later in a court of law, the fact that they got unemployment? It must mean that I did something wrong. No, it doesn't, because thankfully we have a state statute, 40 OS section 2-610.1, that says a judge cannot allow a finding of unemployment into evidence in a later proceeding. Now, what can be admitted? That, right? So your testimony under oath can be admitted in a court of law later, but not that, not the finding. And so you don't have to be worried about, well, but is this going to look bad down the road? That's not the issue. I'm more worried about, let's make sure we have our act together. Let's make sure this is one that's even appropriate to respond to in the first place before you do it. So that's the second thing. Now the third thing is you say, all right, we're going to win, or I don't care if we're going to win or not, and I've got everything together, and I got my documents, and we want to attend this hearing. The last thing I tell employers is this, and this one is the one I really learned the hard way over the years, and this is going to sound totally counterintuitive. But you will be more successful in unemployment hearings and responding if you stop trying so hard to win them. What do I mean by that? Well, you've got to step back and remember what is an unemployment hearing and what is it not. And this is the thing I didn't get in the early days. Unemployment hearings are not about whether you had a good termination or a wrongful termination. They're not about a good employee or a bad employee. They're not about a good business or a bad business. As I said before, there are lots and lots and lots of terminations that are for very good reasons. They're just not misconduct. And so the key thing you have to, I think, remember, and it's really hard, especially for the lawyers that get involved in these unemployment hearings, is you got to stop trying to win so hard. This is only about one thing, and that is eligibility versus non-eligibility. That's all it was ever intended to be about, and we make it about something else. Now, I'll tell you the secret, the really big secret to this that I have learned, and it helps me when I am asked to respond to an unemployment claim. And this is if you don't remember anything else, I want you to remember this one thing, this one takeaway about unemployment hearings. And that is, the hearing officers do not care what you think. I didn't know that at first because I'm trained to be an advocate, right? And so I want to show up with my advocacy hat on, and I want to have a killer cross-examination of this former ex-employee who's just trying to get unemployment benefits. And I've got this closing argument for why it's misconduct and why you've got to protect the fund. And I did it just very poorly for a number of years. You want to get a really testy hearing officer, do that. Because that's not what they're there for. They are fact finders, and they like the person on the phone who's helping them find the facts. That's what it's really about. And so you got to step back and say, this is not about justifying my decision. This is eligibility or non-eligibility, and you need to be helpful to the finder of fact. What does that look like? You got to be timely, you need to be cooperative, you need to get to the point. The other thing that a hearing officer doesn't like is lollygagging. They've got, how many would you guess a hearing officer has in a day, typical day hearings? I don't know, 10?
No, much more than that. The basic, well, I guess, yeah, they can get up to around there. Some of them
10,
go
12,
faster.
yeah.
Some of them
some of them tell you, move it along.
Yeah.
They like to used to tell me that in the early days, move it along.
8 to 12.
Yeah, and so, okay, 8 to 12 a day, they've got, times 5, times at least probably 50 weeks out of the year over the course of their career. I mean,
They docket them a month in advance, so they're all set. The non-notice, I don't need to earmuffs on that because as long as there's communication, we can plan accordingly.
Right, yeah.
No-showing is not, that's not no-showing. The communication is much appreciated because then they can just docket along, what the person is seeking.
Right,
so
and I think that's fair.
great.
Yeah, it's fair. Do the letter. Say, here you go. Here's the information, but we're not showing up. And so you got to get to the point, and you got to have your documents in order. And let me give you one real story about that in a moment, because remember I said the statute says you don't really have to have a warning, but I said it's kind of hard without documents. Let me just give you the worst example I've ever seen, and it happened in a case last year. A rural hospital had called me about a nurse that they had terminated for testing positive for amphetamines and methamphetamines. And I was like, well, okay, thank you for terminating said nurse. And so they responded on their own, and they lost, and they appealed, and they lost, and then I got involved. And I was like, what is going on here? The statute's very clear about testing positive for illegal drugs, and they had, and I wasn't involved in the earlier hearings, but they had presented the acknowledgement of the drug and alcohol testing policy. They had the positive test. They had 3 first-hand witnesses. That's a problem too. Sometimes you show up without your first-hand witnesses, and they never like that. And so they had all this evidence, and I thought, why do you keep losing? Well, I read closely in the opinion, and what they hadn't done was they hadn't attached the drug and alcohol testing policy itself. And sure enough, even though the statute doesn't say specifically that an employer must attach the policy, it does say that the employer has the obligation to show that the test was conducted pursuant to Oklahoma's Standards for Workplace Drug and Alcohol Testing Act. And so and I tried to jump in belatedly and say, well, look, obviously they acknowledge something. They can't acknowledge a policy that we don't have. So we got the policy because she acknowledged it. And you got the positive test. And after all, the burden's really supposed to be on the employee when you get a positive drug test to say that, to challenge the test. But here they said, no, look, and it's too late. You didn't attach the policy, and you had the threshold obligation of showing that you had a policy that, at least on its face, was drafted in accordance with the Oklahoma Standards for Workplace Drug and Alcohol Testing Act, and they didn't attach the policy. So documents do matter. They really do. And I encourage you to give some thought, really put a lot of thought into, are we attaching what the fact finder needs to make the decision? And again, it goes back to being helpful and having all of that in order. Documents really matter. But make it all about eligibility, not about you, it's not about your business, it's not about the employee. It's about eligibility. Use the OESC's language. Use their language. Use the statute. Cite to the statute. Use your good language. Sometimes I still cite to Vester, even though I don't think it's the right standard anymore. I'll say, look, it's intentional conduct. They knew about it. It was a work rule. They signed off on it. We warned them. Use the language. Again, why? Because your job is to be helpful to the fact finder so that they can find the facts that are needed in order to make that decision. And finally, I would say use your tools. What kind of tools? You've got a number of them. Don't forget, there is a precedent manual. It is on their website. For those of you who've been around the state chamber a lot of time, you might remember Mike Sini. He made it kind of one of his very most important and last jobs before he retired was to ensure that this got updated. For many years, it hadn't been updated to reflect the changes in the law, and it was completely updated. I don't know if it still is today, but I think for the most part it is. And you can go in and find different situations that have happened in the past that mirror your situation or pretty similar to your situation. You can cite to those cases too. Again, you want to be helpful to the fact finder who has 12 of these things to do in one day. And so anything you can do, like using your tools for the precedent manual, is helpful. And finally, I'll just end with this and then take whatever questions. You've got another tool as well, and I'll give you this last story, which I thought was just such a great success last year, working with an employer, the state chamber, and the OESC to make a change. I had this one client who called, and I've redacted most of this, and you probably can't read it anyway, but I had an employer who called me and said, look, we've got this employee. She has always worked part-time, 20 to 25 hours a week is all. Sometimes she works for us, but she's also, I think I can say this, there's lots of them, you wouldn't know who it was. She's also a Thunder Girl. And so she takes off from time to time to do on game day, whatever they have to do. They have to leave early, I don't know, something, they take off. And so this employer had discovered that she was filing for unemployment on those weeks in which she worked less than her normal schedule because she was taking off to go to the Thunder games or whatever. Most of the time it was that. You take off for whatever. Whatever it was, she was having a dip in her normal pay and work hours for the week, but she was voluntarily choosing to take off. So I appeal, we lose. I respond to the initial claim, we lose. I appeal, we lose. And so and this goes back to how things are different. I will tell you, early in the first probably 10, 15 years of practicing in this area, I would call over the OESC sometimes and I'd say, listen, I've just got a head scratcher here. I can't figure this out. I don't know what I'm doing. And the response was kind of like, sometimes it was just, well, those are the rules. I don't know what to tell you. I emailed your predecessor, Shelley Zumwalt, and within 24 hours I had a long email back from the General Counsel saying, I'll tell you what's happening is some employees have figured out the loophole in the statute that allows you to get partial benefits for any week in which you work less than full time, which they consider to be 32 hours. There was nothing really making clear, though, that not if you always work less than 32 hours. Because my point was this is not what unemployment is designed for. It's not designed for the person who's working who hasn't lost their hours as a result of a change in their actual job. Yes, if you are full-time and your employer reduces you to part-time, you're eligible for partial benefits. That's right. But some employees had figured out these loopholes, I guess, to be able, or maybe she didn't even know it was a loophole. Maybe she thought it was perfectly appropriate. I don't know. I won't assign bad intentions to her, but nevertheless, that's not what the fund was built for, in my opinion. And so she said, but hey, guess what? We actually have drafted some legislation that would make this much clearer in the statute and fix this problem. We would love any support that, that you all, if you think this is an issue, great. I sent it to Kinsey here at the Chamber, and the Chamber was able to get involved, and I had employers who were willing to go talk at the Capitol if necessary. As it turned out, it wasn't necessary, but the point is, it changed. The law changed, and as of this year, that rule looks different. Now it says, except unless, in the old days it just said, with respect, you were deemed eligible for unemployment in any work that you had worked less than full-time work. Sorry, I butchered that whole example. And they defined it as 32 hours. Now it says, and in addition to that, if the individual has incurred a loss of wages or reduction in hours equal to or greater than 15% of the income or hours worked based on his or her customary work experience or contract of hire. Meaning, it's something different than what you were hired for. You're not supposed to get it just because you're working, you're working less than 32 hours a week, but you've taken off work to go somewhere that particular day. That's not what it's for. And so the statute changed. So my point to all that is, if there's something that you are consistently encountering that you see that you think might be a misunderstanding or a misapplication or maybe just some law that needs to be changed that you're consistently seeing, you have other tools available to make changes to that. And partly it is partnering with the state chamber. That's what this building's built for. That's what this whole place is for, is to work with the business community to try to make changes in legislation and laws and regulations that affect employers. And I think in the last couple of years, as I mentioned at the beginning, I've just seen a tremendous response by the OESC that we did not see in the past to try to address those issues as well. Because again, if you hear what I'm saying, you're stepping back. We've all got the same objective here. The fund should be protected and available for those who need it. It's an important thing for our state. We know that. We've watched what happened when a whole lot of people needed it. And so we all have that. But to do that, it can't be available for those who aren't eligible and who are receiving it for purposes that don't fit the intent of the act. And on that, we're all in agreement. We're all aligned. And so anytime, but I just think over the years, there's been this thought that, well, it's just what it is. I mean, that's just the rule. And I don't think it has to be that way. I think we can come together as employers groups, council if necessary, and the OESC to try to ensure that eligibility is really there for those who need it and not for those who the act wasn't intended to protect. So I think it's a success story. Kudos to the state chamber and to the OESC for taking that issue on. There are others I'd love to work on too, like drug testing policies having to be attached. But it's all good news. So anyway, that's it. I'm happy to take some questions, or we can both tag team and answer some questions as well.
I would just offer support for that last point. I mean, we want to know if you see something and it's not worked on, if you think it's wrong, we would rather have the feedback because we've got a pretty sharp team and they're able to figure things out pretty quickly most times. And usually we say, don't be shy. You might see something we didn't see, and so yeah, we very much welcome feedback.
Yeah.
So I had a situation that kind of left me scratching my head through the process. We had an employee who was terminated for a safety violation and also an OSHA standard. They filed for unemployment, so we responded. And then we actually got a hearing that was scheduled, so we looked at the documentation and what their responses were to the questions they were asked. Two things that the notification said. One was to determine if basically, if I read it correctly, if basically OESC was going to accept the dispute by the former employee because they missed the deadline for the dispute, so they were going to, weigh that out. And the other thing, when I read through the documents where he had responded, he admits to, I knew I shouldn't have done that, but I did it anyway. So I'm going, why did we schedule a hearing? I mean, he was late in responding, we weren't. and he admits to violating, maybe, I don't know if we attached the policy, maybe that was the thing. But that one kind of left me scratching my head about, I just wondered why, and the employee didn't show up, so it never went through.
Yeah, so we do have that happen quite a bit where people don't show up. Let's do that in case you guys hear me, I'm so soft-spoken. The thing that we typically see when people fail to appear or fail to respond, we're not a judge and jury where we'd say, well, they screwed up, so we're kicking it. We can't take away their appeal rights. Most of what we do in making eligibility determinations are very strictly written in statute. You probably know that. Because we're having to decide, kind of who wins in those.
But he didn't show up after, the hearing was scheduled even though he had said on paper that he did not follow the policy, and he was also past the deadline for the dispute, but the hearing was still scheduled. So that's where my question was. I didn't understand why a hearing would be scheduled with those two reasons.
Yeah. Good question. I think I will tell you, and it could be a timing issue, and then I'm going to Jim may be better at answering this, but if the non-appearance was within the time when the notice period goes out, so someone doesn't respond, we still have hearings that get docketed. For someone's appeal rights, we have to docket everything that comes through as an appeal. If they don't show, which a lot do not show, then that doesn't go anywhere. But we usually are docketing them in the past. We've docketed them, you can do months in advance, which is not good because a lot fewer people show up when they should if it's on the calendar for 3 months from now. So now they docket 1 month in advance at a time. So we do see, honestly, a pretty significant percentage no showing. Sometimes we speculate that it's because they knew they were going to lose because it's written right here, plain Jane. But we still have to go through our full process because we're granting them the opportunity to have an appeal case, have their day in court. Jim, did you have something to add?
That's what it is. It's all due process. The first hearing they're going to hold is to let the claimant explain why they didn't get their information in on time. And then once they do that, they will go ahead and schedule the subsequent, over the actual reason for separation after that. And even though he admitted it to it, he still has the right to appeal it. So that's probably did they even hold the second part of it?
No.
Yeah, because if he can't demonstrate good cause for filing the appeal on time, they'll dismiss the actual appeal on the separation issue.
And we usually, when we're looking at something that, Courtney painted a couple of those pictures, you look at it and be like, well, my 5-year-old daughter could say that this one shouldn't go anywhere, We have pretty strict, rules around making sure that there is equitable access and that we're not, cutting any corners. And there are those types of attempts to increase our effectiveness and our fairness all the time. We get to hear from our federal Department of Labor pals and they're like, well, shouldn't we give appeal rights for this? And we're like, in the interest of employers, typically we're responding in the interest of employers saying that's a terrible idea. That's not good at all. Why would we ever do that? And so, but we do have to go through the bodies that write our checks because they're usually saying, we had this one case in Tennessee in 1986 and that person should have gotten it. And we're like, we don't care. This is not, you're asking a whole bunch of people to do things that are not time well spent on the if. And so we fight those battles in a lot of ways every day. But that's one of the reasons earlier I said we'd love to interact with employers more because, and I used to say this in my private sector life, if we're charged with getting something right and you're the one doing it all the time, flood us with information, flood us with examples because it just makes our case stronger. We see something needs to change and it's really painful for people. We want to make sure we understand those things and continue to beat that drum.
And where do we provide that feedback?
Any feedback for us. All of our local offices you can send emails, you can call us. Our information, leadership contacts are online. So if you feel something needs to be said, then you can take any one of those measures. Yeah, yes ma'am.
Sure, one other thing on those appeals, and I believe, Courtney, please, you'll know more about this than me. But they're called de novo hearings at the appeal, which means they basically start over. So because they don't swear anybody in when we're taking our fact-finding statements, but they do at the hearing, if there's contradictory evidence given at the hearing, they would probably hold more weight on that than they would from the original statement. So when you were talking about not showing up at the hearing, I was going, what? But
I know, I could see your face. I was like, I'm sorry.
it makes sense when you explained it. But like a lot of times if an employer doesn't show up, the claimant can say, oh no, I didn't say that, or they misheard me, or they miswrote or something. They will still interrogate, that was wrong. They'll still question them about, why did you say this, Dan? And sometimes they know BS when they see it, so they go ahead and affirm a decision to deny the claimant. But if the employer's not there to, cross-examine that person or something like that, sometimes employers lose simply because they didn't show up there.
That's a point I forgot to say. Yeah, I also tell clients, you're going to lose. I mean, when you take my advice and don't show up, you're going to lose. I mean, I have had it happen where it's just so obvious that an employer still will have a denial, there will still be a denial of benefits even without the employer showing up, but you cannot expect that you are likely to, I shouldn't even say lose because I told you it's not about winning, but you are likely to have an approval of the benefits if you don't show up, because for that very reason, there's no one else to say no, that's not how it happened. But sometimes that's just okay too.
And response obviously is the first way of qualifying yourself as an interested party. From the standpoint of hearing and eligibility, interested parties would likely be there telling their side. So if we don't respond, then you're not considered an interested party, so you don't get notices and you don't get updates on how it's going. Similarly, if someone says, yeah, I knew it, I did it, I put it in my statement, like I'm obviously going to lose, they're probably not coming because they're not an interested party. But everything that we do, we have to make sure that we're cognizant of who is an interested party, because everyone gets their day in court. But that's some of the reason why, even where it's real antiquated, like we'll work on changing those things as long as we're aware of them. But sometimes, when we're out in our local offices, we say, assume we know nothing, tell us everything that bugs you about any barriers to doing the job all day, any barriers to supporting an employer, anything, because they don't touch hearings. That all goes through our appellate division. But we ask, we want to know. So same goes for you.
I have a question in reference to kind of a question that was earlier. If we don't receive a response back in reference to a case, can we now go on to your new website and be able to find that? Like, we had an unemployment hearing a couple of months ago now. I never received a response to whether we did or didn't win.
Okay.
So I don't know if the person's receiving unemployment today or not. And we've had other cases where we just responded back and there was never a hearing, but I never heard back if we won or didn't win.
So, Dee Dee, if someone opts into using the employer portal right now, I know they would get those 2 notices electronically, but what about other case information that would be visible if they were to go into that employer account? Not yet?
Not yet.
Okay.
Just those 2.
So,
How do we find out?
I'd say you can definitely reach out to us, because our appellate division's answering questions all the time about what's going on or what's happened with past cases. They get a lot of those inquiries, as you probably imagine. But our intention of further developing that portal is as there are additional, so basically the way it works, I won't bore you to tears, but there's parts of our business that exist on this subsystem or that subsystem, and they're disparate. They're not in one system. So as we get enough of it, the employer portal coded to move that information in, then you would be able to see and interact with more of that data that's there. So we have plans on loading in more notices that you could respond to via text or email, and I think we determined that we're probably a couple months away from loading the next round of notices that you'd be able to see. So we're going through a process of just continuing to add in so that you could see just a one-stop shop, single sign-on, make it a little easier. But that's another thing we'd love feedback on. Certainly if there are huge groups of employers out there saying, we just want this in it, then we may be able to prioritize that in our roadmap and go there next.
So in your organization, who is the appropriate contact for getting that information?
For appellate questions, these folks back here are division directors, so they are the business owner for that area, and the division director for the appellate division is Deborah Goodwin. She goes by D.
So when we
her
go
information's
onto your
available.
website,
Yes,
it will have that
an
contact
email address.
information?
Yep. Yeah, and if you're ever...
Not to interrupt you, but we can also send an email out to everybody
Yeah.
afterwards. I'll get with with them and get everybody's contact information and send it out to you guys directly in a push email, so you have it all right there. That
Yeah,
works
that's great. And we've been putting together one-sheets on our divisions and contact sheets just to pass out the legislature or give to employers when we're at events, just so you have, you know, a good name and number. But I mean, when in doubt, you can go online, or you could reach out to me, or you could go to any of our partners that, you know, we hear from, and they, oh, I know someone over there. So if you're ever struggling to get a hold of someone, I mean, you could literally send an email to me.
I appreciate that, because it's been challenging the last couple of years trying to figure out who to contact to try and get the information.
Yeah, well, we're trying to keep those things updated now because we're changing a lot. So, you know, it could have been really an effective way to get information a year ago, and now we've reshuffled that workflow. So we don't want you trying to reach someone who we've asked to do something else.
Thank you.
Yes, ma'am.
So you say attach the policy. If it's not signed, is it valid?
Well, in the case of a drug test, I would say what I understand the OESC requires is that you establish that you have such a policy. So I would say attaching the policy is your first step, and even if it's not acknowledged, you might still be able to prevail on an employment claim, because then technically the burden's supposed to shift over to the employee in the case of drug testing only, to then say that they weren't tested or they challenged the test or something like that. So I don't think you have to have the acknowledgement, but if you do, obviously it's much better for you to be able to say that they were aware of the rule. But technically speaking, the way I read the decision that we got on that case, you should be able to just attach the policy. But if you have more than that, I'd get it.
Because there's kind of peripheral ownership. If they've signed an employee handbook, or they, you know, you assume that by working here you're going to follow. Yeah, make your strongest case. If it's not signed, then unsigned, as long as it's what governs your business. That's going to.
Keep in mind, you can provide that, and if they challenge a chain of custody, you can't show that, they're going to win.
Yeah.
Are there any policies that need signed more than at onboarding?
I wouldn't say more than any others, but I mean, I think, and by the way, I don't think you have to have a signature on each individual policy. I think a global acknowledgement of the policies is sufficient as well, as long as it's clear that it covers whatever it covers the handbook, and if it's in the handbook, that's fine. So I don't think you have to have separate signed acknowledgements of each one, but drug testing would be a biggie for sure. And then also, in addition to just anything that lists your work expectations in terms of rules and behavior. I mean, those are always the ones you're usually the ones you're talking about in an unemployment hearing. But I think one global acknowledgement is certainly fine.
Yeah, and I know we're at time, I don't want to make y'all too late, but as we modernize our workflows inside the agency, we're going out with a lot of communication saying, we've changed this, there's an easier way. We've changed this, there's a better way. So we send a legislative newsletter every month. We send notices just kind of around the different groups, but our plan is to continuously be putting information out on things that we're changing, things that we're modernizing. So in this case, I think there's tips and tricks that we learn as we engage with employers, especially within specific industries, saying, oh, that's great advice, but the majority of employers we work with in that same industry, they don't do it that way. They don't document that way. Their process stops short of what you just demonstrated. So maybe there's an opportunity to kind of rising tide, you know, give people a little bit of a head start, you know, if it's a practice that proves to be effective and others have been kind of slower to learn it or not there yet.
Back to your Thunder Girl.
Yes.
I appreciate that the part-time has been closed, but is there any thought to trying to close it where, in your example, she was the one, work was available, she was the one choosing not to work, to close that?
Yeah, so before the change in the legislation, we did a workaround, which is exactly that, and we changed this employer's forms to say, and we basically had them sign off. I think she may have even done it week by week. I don't remember, because this was a very upsetting example. My letter was written in the way that I described to you to do it, which is, hey, we're just wanting you to know that we're not sure if this person, you know, should be eligible for benefits. But behind the scenes, it was very upsetting for this employer, because this person could have worked even more than 25 hours a week, but was choosing not to. And so our workaround was we drafted documents for them to sign that said, if you wanted to take off, you understood that there was a full amount of work, your normal work schedule available to be worked or something like that. I forget what wording we used, but we did do that as a workaround to try to say, this is your normal schedule, these hours are available, and to try to cut that off at the pass. I forget exactly, like I said, how we worded it, but there are ways to do that as well.
Because we do weekly schedules and we have a lot of part-time employees or people that are right on that bubble. And so we
Yeah.
need to make sure to close that.
Yes, yes.
When did that go into effect?
So it was passed at the end of last session, so it would have been 2020, yeah, 20,
November 1st.
I think it went into effect November 1st of 2022. So we now have that rule.
It's all part-time employees, and so I've run into that continuously where people got unemployment, and I'm like, but they never worked more than 20 hours a week.
Right.
And they were getting unemployment, and they could have worked more, so.
I was
somewhat
stunned.
appreciate that.
I was just stunned. I just thought, this can't be right. And I'm appealing, like I said, I didn't even realize this was a problem until I reached out and said, yeah, no, this happens, and we're actually working on trying to change it. And so I think it was a really, really good change.
And I had mentioned we want feedback if you see something you think needs attention, but honestly, I mean, this is probably the best answer you can hear. It may not be the most convenient or pleasing, but finding these things that people are able to either ignorantly, not with bad intention kind of loophole, or they're seeking a loophole, because some people do that. Your best friend in the whole world will be yourself learning from yesterday. And that's honestly what it takes. A lot of industries closing those silly loopholes. It's the same way with our legislative process. A lot of the rules that govern from federally or from state statute standpoint, they're written a long time ago. People are continuing to progress and get smart and find new ways. So I hate to say that because I think it paints a fairly negative light, but at the end of the day, your business is going to be more your responsibility and interest than anyone else's. And so I think as you learn things and you say, gosh dang, we're already having them sign 80 things. Well, it might need to be 85, and that's not a great answer, I know, but we're kind of all in it together to some extent to make sure that it's happening right. And so there are things we can learn and modernize and continue to get better at, but the people on the other side of who are trying to figure these things out or trying to defraud the system, they're figuring out and learning too. So if we stop and we think this is the packet, 10 years later, it's going to hurt probably.
Okay.
To end on a high note. Sorry. But it is good. I mean, we tell ourselves that a lot. I think that's important.
Sorry, I think it's a really quick question. If we decide we're not going to contest a claim, is there best practice for responding to it or not? If we don't respond, that's our response that we're not going to respond? Or should we just reply back and say, we're not contesting this? What's the best practice?
I like doing the very short letter that just advises the OESC, because as you said, they're planning these dockets a month out in advance. I think it's appropriate, and honestly, it's appropriate too, just in terms of, again, our shared goal of being protective of the fund and making sure it's available for those who need it. I do think an employer ought to respond and just say in a short letter, I mean, I do it in like 2 or 3 sentences. Here's the dates of employment, here's the documents, we're not showing up at the hearing.
Yeah, please do respond, because if you think about it, there are things that go through, we have throughput of, these items go through our process and get resolved on the other side. Anytime we have called an appeal is coming through, we've got this many appeals to docket and get through. If we know someone is not going to contest and we have the communication that closes that loop, it makes room for us to put someone else in that spot. So think of it as kind of no showing an appointment, essentially. It's okay to not contest them for sure. And same for the employee. They may say, I'm not going to waste anyone's time. Well, if we don't know about it, then time's sort of swept.
We're trying to get, I'm sorry, Jim.
Oh, go ahead.
We're trying to get better in how you can respond as well, right?
Yeah.
Electronically, for instance, I've got staff that are asking you guys to fax something in, and they've never seen a fax machine.
Yeah.
Just for responding to.
We've been, OESC's been great for the fax machine market. We've sold a lot of fax machines. It's not our interest to continue into the future with technology that we have to put gas and oil in. So just give us a bit. We're working on on it.
That's so true.
If you don't respond, and it was a separation issue other than liking work, we're going to call it. So you might as well cut that in the bud too, and just respond, say, we don't plan on protesting, we won't include you on the decision. But if you don't say, we are not protesting this claim.
Yeah.